My lord, may I take the liberty of mentioning before the special bench, there are two civil appeals which have been tagged along with this contempt, which arise from the NCDRC. This court had directed monies to be deposited. Sahara India Commercial Corporation is the respondent. We have entered into a settlement agreement for the home buyers that will simply withdraw the money and close the matters. My only request is, my lord, the matters may be listed. I'm mentioning before this bench because somehow it has been tagged along here.
So there are
We'll give the number. Grateful.
there are a large number of claimants. Ultimately, your lordship will have to decide.
It's only
Today, for example, some employees of Sahara have made applications. These are small claims. Sahara will have to verify and then we can take.
I'm only praying list the matter, your lordship may see.
Whenever next time the bench is bench assembly, it will be listed. Today it can't be.
No, not today. I'm just praying for the listing. I'll give the number. Your lordship may list it whenever the bench sits next. That's all I'm asking.
My lord, may I be permitted to withdraw an IA number 21178?
May I have a word in this, Malas, because we are presenting the plan, Malas.
not before that.
You are appealing for whom?
I'm appealing for Sahara, Malas.
To examine the claims of those workers and all.
That's right. That's why we have suggested a process through which that can be done, Malas.
I
can't do
number
it.
7 and 10. They relate
One
to
second.
employee.
We are suggesting that
At
setting
serial
up.
number 7 and 10.
Only 1 minute, my lords. If I am hurt, my lord, I am not coming in the way of any plan being considered. I cannot. But this may, my lord, this appears to be a good suggestion, subject to, my lord, various factors gone into. But government also, my lord, central government also may have to examine and put its my lord, thought before your lordships. My lord, the request is that if your lordships can consider implementing the secretary finance and secretary cooperative societies. There is a cooperation department now, because there are some cooperative societies which are, my lord, they have invested through members, etc. So, my lord, we can also, my lord, present our picture.
And who is appealing for SEBI?
Sir, I appear for SEBI.
You will also have to examine the proposal.
Lord, there is as far as the proposal is concerned, my lord, that other than that, about the salaries, your lordship is asking about the salaries.
Please, the mic.
Light.
Your lordship is asking me about the salaries, etc., my lord.
No, this proposal.
Proposals, right, my lord. Your lordship. There's already orders passed by this honorable court, my lord, that the properties can be sold by Saharas not less than 90% of the market rate. That is because, my lord, SEBI, initially what happened was SEBI was tasked with the job of disposing of the properties. We couldn't do it, my lord, because of the many, my lord Justice Sundari should know, because lordship was on the bench which heard this matter last. We could not do it. And therefore, my lord, Saharas on their own plea, my lord, in fact, my learned friend, Mr. Kapil Sibid had made the plea and it was allowed. This honorable court said you can sell all properties not less than 90%. My lord, we are not into, there's no requirement for us to examine any proposal, my lord. That is, if they are in compliance with your lordship's directions, that is all has to be seen, my lord.
We will have some objection on.
There is
We are the buyers of those 3 buyers.
Since
But some of us have got decrease in our favor. Some of us have got. Those properties are listed. I appear for 3 buyers. Out of 75 acre, 50 already registry is done. That is also included in that. Another one, I have been given power of attorney fighting the revenue litigation, getting it cleared. I am doing that, paid 10 crore rupees. So, most of those properties, maybe I am appearing only for 3. Maybe there would be others also as there are others. Nothing is disclosed, and my lord, the tenor of the application, if my lord sees that everybody has to come here, all disputes will
So may I make a suggestion? My suggestion is this, that at least by 4 orders, your lordships have said that Sahara must first deposit the principal amount, which is about 25,000 crores and odd. As on today, they are in deficit about 9,000 crore.
9481.
9481. 9,000 crores, 481. That is the deficit. Now I
That
suggest
was about 15,000 crores.
16,300.
16,000. Now, as per the original order of
the amount which is being separately disbursed through the committee appointed by this court.
No, my lord, the total liability, principal amount
under the
was
orders of your
the
lordship
first
court,
judgment, my lord, which is of August 2012, the initial judgment.
No, there is a committee constituted headed by this court constituted.
No,
by
there is
this
no
court.
committee, my lord. What
That's
the
the
direct,
thing.
there is no committee, my lord. The
Agarwal.
Justice Agarwal, the retired judge of this honorable court, was appointed to oversee the SEBI effecting the refunds. According to SEBI, all refunds which we have done, and we have also moved in applications before your lordship saying that we have completed our.
Pointing out something. Which,
Yes.
Mr. Solicitor General will be able to tell the more detail.
Yes, my lord.
About a couple of days back, the matter came where already there was an order by this court to disburse 5,000.
My lord, that's in a connected matter, my
With
lord.
the cooperative society.
Cooperative society.
Sir,
That's a different matter.
Of a cooperative
As far as
society.
that matters,
This liability or deficit is other than that.
Other than that, that is a cooperative society, my lord. We are concerned only with two companies,
No, but
Sahara
that's
India
not
Real
correct. It
Estate
was
and
adjusted with the fund. That is already SEBI Sahara fund. That cooperative societies, the payment was made under the SEBI Sahara fund. Anyway, if your lordships have gone through this application, Mullah,
sir, may I
the
make my
9,000
suggestion?
crores my learned friend is talking about will be deposited, Mullah. In fact, more
Sir,
than,
may I make my suggestion?
more than that.
Not today, Mr. Singhal, let the Union of India. And
Yes, I
all
am
the
not-
stakeholders.
we all have-
First of all.
I have one suggestion. This application has 88 properties that they wish to sell. Of those 88 properties, several of us have applications, some listed, some unlisted, where we say either that they were sold to us or they are aggrieved in some other manner because there are
Like we
judicial.
said, there's a power of attorney. in-
Correct. So there are judicial, there are proceedings, there are agreements, there are sale deeds. One suggestion is, if each of us can intimate amicus among those 88, which are our application numbers, the lordship may look at that, which will leave a residue, which they can get their orders from this court. That's my suggestion.
We have proposed an oversight committee which should look into each of these claims and then decide on the matter instead of your lordships being troubled on a daily basis.
No, but
That's the
their
proposal.
prayer says everything will
That's
be
the
this
proposal.
court. And that's the problem. One matter, there is a civil suit going on out of 75 acres for 16 acres. I am also dealing with that. So, Malad, they are saying that everything will go. So, Malad, we don't know what all rights and wherever it will go. So at
Question
least,
is, who
Malad,
will decide?
That's
this?
all.
That's the question, my lord. There's someone will have to decide. It normally cannot be your lordship's.
It's better, I think, the central government and the learned amicus, you apply your mind to the application
Exactly.
and also
So if your lordship permits me, consider my suggestion.
take into consideration their objections because they say that they have
We'll give them
exercised right in respect of certain properties. So whether such
Undoubted.
properties also
Sir,
could be a part of,
So first
Flash.
Sahara will have to deposit that now 9,000 crores and odd.
No.
That is point one.
no, but that he is saying that once these properties are
Yeah.
disposed of, he will be depositing more than what he is.
No,
required
but
to
in
deposit.
fact, the person who is buying it is going to deposit 12,000 crores,
Sir,
not
in
just
that
9.
respect only, I am making my suggestion. If my learned friend permits me to put it across.
Mhm.
So my suggestion is, first, that principal amount of 9,000 and odd crores, Sahara will pay. Then the question is of interest. That under the original order of your lordship's court, they had to pay it with 15% interest. But this question is kept open by subsequent order that your lordship will have to decide. Once your lordship decides the question of interest and that amount comes to the kitty, then whether Sahara sells it for 2 rupees or 10 rupees is something with which we may not.
Interest to be paid to
One
whom?
minute.
Where are the depositors to whom the interest is to be paid? My learned friend, who is going to get the interest? What are you talking about?
My lord, as far as
Interest to whom?
as
There are
far
no
as-
depositors before
That's
the
the
court.
order of the court.
No, the court says this will be decided later. Don't say
That's
that.
what I'm saying.
My lord, as far as SEBI is concerned, all the investors have been repaid, those who are there.
Only
And
if
we
the
have moved in
investors are
application
found,
saying,
will there
in
be-
accordance with the judgment, the money should go to the central government. Because that is what the
Okay,
judgment said.
central
If
government.
there are no more investors, the balance should be handed over to the
But that's the question.
government of India.
That's a
So,
question
my
of
lord, the
debate.
government of India should be heard.
Government of India is also a very.
Yes, my lord.
Stakeholder.
Yes, my lord.
Them also examine
Yes,
the process.
in fact, they should be permitted to intervene, my lord, because,
Honorable CJ has pointed
Yes,
out
ma'am.
that let the Union of
yes,
India.
Union of India should be there, my
They
lord.
also can examine.
Yes.
The decree,
Exactly.
sir, the decree as it stands, 15% interest.
Only if there are depositors to be found, not otherwise.
Lords, may I
suggest something, my
Lord, may I be, I have filed an application, my Lord, where I want to buy 12 of the properties, and I have given details of that. Now, Mr. Principal's, my Lord, proposal, whether it includes that or not, we don't know. But we are people, my Lord, these lands are situated in different states, Tamil Nadu, in Karnataka, in Kerala, in, my Lord, Orissa, and other places. So we have given details of that. We wrote to them, my Lord, about it, that we are wanting to purchase, and my Lord, they never answered back. Therefore, we have had to make this application before my Lord.
So you can't compel a seller to sell it to you.
No, I am not saying compel, but I am, my Lord, saying that I am willing to match any offer.
I think the offer is holistic offer.
Offer is holistic. So therefore the focus is also be holistic.
Good evening.
My Lord, may I say something? My Lord,
I am
respect.
willing to match any offer, my Lord. That I am not saying.
Offer can't be in court, Mr. Kumar. There
No.
has to be some, it has to be in
no, my Lord.
public domain.
I am not.
And there all, maybe there are other competitors, other bidders who might offer maybe 10 times more than you.
So therefore, my Lord, that's what I am saying.
That's
my Lord,
what the learned solicitor also says, that there has to be some forum where all these issues will be
Please,
decided.
please.
And it can't be this court.
I bow down, my Lord. So
That is part of the proposal, Manoj, an oversight committee.
The problem is this. One is with respect to the competing interests of all the parties. What is
Yes.
stay, some will be agreement holder,
Please.
power holders and sale deed, pending dispute, all those things. Second is whether we have to accept the scheme and then go for a one purchaser or in piecemeal. What you are saying is piecemeal. So these are the issues we have to consider.
yes.
Now, the problem with what you are saying is that now there it will be endless.
Correct.
Now, once
So
you
if
purchase.
there are 100 properties, 100, so prima facie, his proposal appears to be subject to the claims of the others, wherein the rights have already been crystallized.
No, but I am not-
Value maximization would be
that's
the
right.
I'm
idea.
only on the maximization part.
Because maximization, that will take care of.
What we are also asking for is about 700 acres of land, my Lord.
No, so
So
therefore.
it's not a small piece of land, but spread over different
No,
states.
I don't know what happened in that golden forest. We were appearing in.
Yes, Lord, I was one of the parties who had given that.
Well, it's almost everybody appears in it.
Golden forest.
Almost everybody appears in it.
No, no.
Now one for the other bench.
Yes, we were, I think, Justice Dipankar Datta. So there also we had directed the income tax authorities to value the property. And then we had said that selling property in piecemeal, it's unmanageable. Therefore, we had directed that a consolidated sale of all the property should be done. And it should be by tender process.
My lords have held that, my lords, at least state-wise, they can do that.
Fragmented
No.
sale.
Because Hyderabad, it's been unencumbered, your lordships have.
That prayer, when I was sitting, I had rejected that prayer. We had said that there has to be only one sale.
Lord, I have something.
May I bring,
Lord, can I have the 90th. My Lord, there are 88 properties which Mr. Sibal is proposing. I mean, the 89th property, which is not concerning that.
No, it includes the 89.
No, it is not. It doesn't. It doesn't. We have checked up your application. Where, my Lord, the parties have settled in a mediation which happened in this court. So that is awaiting my Lord's approval, my Lord. The mediation report is here. That may also be.
that's been in sealed cover,
We have no problem.
and it was based on your lordship's direction in January.
Except crystallized, those will have to be left out. Even court
There's
decrees, etc.
one other aspect, which is not only about third-party rights. Some lands cannot be sold. For example, there are two which are wetlands, where anyway there is no question of selling that land. That land could never have been subject matter of this list.
True.
There is another where it's agricultural land.
Even if he purchases the wetlands, it is his problem, he will not be entitled to
Construction
do any construction
Our order will not give it clean check to them, so otherwise.
unless.
The problem is when your lordships give
No,
you a blessing
no,
to
if-
88, they will sell.
If somebody wants to
Sorry.
directly purchase, knowing that he can't do anything on that.
Correct.
Lordship, may I am one of the two surviving directors, Madam Vandana Bhargav. Lordship, my writ petition is of 2018, and Lordship, it has been tagged with a contempt petition. Unfortunately, in today's list, it is not mentioned. Writ petition civil 877.
Lordship 2018. So it is pending for the past 8 years, Your Lordship. And my personal assets have been attached, Lordship, entirely for the past, Lordship, since 2013. Contrary to, if I may submit with greatest of respect, contrary to the judgment passed by this honorable court, this may kindly be disposed of, Your Lordship, or detagged with the contempt, so that, Lordship, I am 73-year-old already. Madam, I am one of the 2 surviving lady directors of the group. And my personal assets have been attached. And my passport has been attached for 14 years, 2013 to 2026.
If my learned friends permit me, my suggestion is this, I'll put it in writing, how this tangle can be resolved. I'll put it in writing, let my learned friends respond to it. My suggestion is this, that first, this deficit amount, Sahara has to deposit. Second, the question of interest, your lordships will decide. Third, as far as the third party claims are concerned, which are already crystallized, something will have to be done about that. Either Sahara settles or the new buyer wants to settle it. As far as claims which are not yet crystallized, they have their own remedies, they can adopt those remedies. I'll put all these suggestions in paper and make it available to anyone who wants to.
That is better.
And
My lord, the implies who has not been paid, my lord, at least their request has to be considered, my lord. In earlier application, in the earlier application, my lord, Honorable Justice Surikant has passed an order, my lord, in which all the implies they were paid from the Sahara SEBI account, my lord. That is around 10,000 crore is lying, my lord. They are contesting for thousands of crores. They are forgetting out 100 crores, my lord.
And your lordship, may I in-
Sorry, my lord. May I just take one
Yes, my lord.
small indulgence at my.
For the employees, there are 150 employees.
etc.
Yes, my lord.
Judges speak.
Like we have already ordered to pay to.
My lord, the one set of employees has been paid, my lord. The another set of employees who were working with the Sahara Media, my lord, they were not paid, my lord. Their entire amount is pending, my lord. That has to be cleared, my lord. This is very small amount. Very small amount, my lord. This IA number 10, my lord. IA 9 and 10, my lord. IA 9 and 10, my lord. Hardly 190 employees are there, my lord.
I will take care of these IAs which are there.
By the employees.
My lord, the IAS doesn't have any issue, my lord. Implies issue, my lord.
Small request. I am not concerned with sale and purchase of any of the properties. Notes by the main order, your lordships, clause number 8 has directed all the proceedings to be kept in abeyance which are pending before different forums. That order, your lordships, in 2024 has relaxed to certain extent, meaning thereby, my lords, those who have already approached the relevant forums, maybe a civil law or a commercial law before NCLT, those proceedings are allowed to be proceeded further. That order, your lordships, would get at page number 36 of my IA. That order is already there, so I just want that liberty. My application may be allowed. My proceedings under section 9, which are filed before Mumbai NCLT, they may be permitted to be proceeded further. If your lordships have the chart which has been submitted by the learned amicus, my application is mentioned as number 6, my lord.
IA number 10, my lord. 9 and 10, my lord, for implies salary issue, my lord.
Yes, my lord, it is only that.
IA number 9 and 10.
And then there's another IM law 74972, which is
Granted
listed today.
liberty earlier,
May I suggest, your lord,
that wherever proceedings have been initiated, they should
don't
not.
My lord, they are suffering for years, my lord.
And that direction has been relaxed. So I'm just requesting for relaxation to that extent.
Lord, may I just say something, Lord?
I have listed IA.
Lord, I've been in this matter now for 14 years. Now, Lord, I think basically it can be divided into 3 parts. One is making the deficit. Secondly, sale of properties, and then dealing with all the miscellaneous applications. Now, Lord, there are 2 things. There are 88 properties. I don't think there is a dispute regarding all properties. If the Sahara Lord, what happened is Sahara companies have the liberty to sell any property of their choice. It should be 90% of the guideline value of circle rate. That's all. They can do whatever they want. Now, out of the 88 properties, not all are in dispute. So if they can segregate those which are clean properties, so to speak, that can be taken up and sold, and that 9,000 deficit can be paid first straight away. That's my suggestion, my lord. And then lordship may fix a date and dispose of the IAs or employees, etc. separately. That's my suggestion. And there's one more thing, they have given a seal.
Implies IA, my lord, can be disposed today itself, my lord. There is nothing.
Please allow.
Yes.
Lord, there are some properties which are not owned by Sahara at all. For instance,
Let him finish.
so may I?
I'm sorry.
No, I'm not finished, my lord. What I'm submitting is, my lord, what happened was the properties are first given to SEBI to sell, but there were so many problems and encumbrances. We appointed State Bank, real estate, we could not make it. Then finally the court said, Sara, you sell whatever you want and just report to the court that we have sold this property at 90%. That's all. Now, according to Mr. Sibal, there are some 88 properties which are now the subject matter before your lordship. I don't think everything is in dispute. What are not in dispute can be put into one bucket and disposed of. Water in dispute can be placed before your lordship and sorted out. Somebody has got this claim, that claim, or that committee which your lordship is referring. So, my lord, one thing is, Acha, there's one more. There is one seal cover in the Supreme Court.
Yes.
Where Sara has given additional properties which are worth 1,60,000 crores. That's what they have said in affidavit. One cover is before your lordship. Even some of those properties can be sold. Just 9,000 crores are left, my lord. Once 9,000 crores is paid, now SEBI tried to identify the debenture holder. First of all, there is no deposit here. It's a debenture holder. We could not locate the debenture holder. Supreme Court has said if you can't locate the debenture holder, give the money back to the government. That's all.
How can that be? Anyway, be that as it may,
May I just add
my
one
learned
thing?
friends is, mothers, if I start selling this property, there are any number of claims I have not been able to. I've got a buyer now, mothers, who is willing to buy everything.
I
Now,
appear
if he
for the
says
buyer.
that you allow me to sell, mothers, how will I sell? It is attached by ED. I can't
I
sell a single property.
I am Adani Properties. I have made a comprehensive offer, my lord, which is before your lordships in a sealed cover. I don't know the numbers myself, my lord, account. Lord, I have made an offer of buying all the properties. Otherwise, this litigation is endless. My lord, one chunk at Versova was tried to be sold. There are decrees, there are attachments, there are injunctions. I have made, my lord, a comprehensive offer. It is my request, my lord. I came across an order passed by Justice Suryakant's bench, my lord, some time back, where a husband and wife, my lord, two people came and wanting to sell all their properties. I think my lord has passed an order. This is what I am proposing here.
So we have not received this.
That is Keshav Rao Bhapkar's matter. My lord, Justice Suryakant's bench has passed a very detailed.
Where there were about 400 or 500 properties.
Correct. So, my lord, the idea is only the, otherwise, my lord, it's impossible. This struggle will go on. 12, 13 years have gone by. My suggestion is, your lordship may, my lord, send it to a committee, which, my lord, the solicitor may appoint, suggest, the court may suggest. They can examine it. Because, my lord, I am also saying that I will take it with these kind of claims also. Otherwise, my lord, if everything has to be clean and without anything, then Mr. Sibal's client, my lord, will spend maybe one or two.
What about the properties where the rights are crystallized?
Exactly.
So that the committee will decide how to deal with it.
So the committee will
Can't
look into
unwind
it
everything and finish off.
Let the solicitor take instructions.
Yes,
Not the committee can say that out of 500 properties, 10 or 20 have already taken care of crystallized decrees.
May I just give one example?
One minute.
They may be extra.
IA number 232892 of 2025. This application is filed by Sara India Real Estate Corporation Limited for certain direction.
It's not filed by Sara India Commercial Corporation Limited. IAs are by.
No, Sara India Real Estate Corporation Limited.
No, that's the main company, my lord. That's the main company. The application, lordship will see application 232656665. The applicant is Sara India Commercial Corporation.
That's correct.
What is your IA?
Your IA is 232892.
Yeah, there is no applicant, my lord. In 23892, there is no applicant. They just say applicants.
There are two IAs, mothers. My learned is not.
Lordship will just take 2326665. It is by Sara India Commercial Corporation Limited.
That's
It is
correct.
not in the main dispute at all.
There's another application.
Very good.
And the other application is 2328925. There is no mention of who's the applicant.
232665.
Lord, may we Lordship just have a look at judgment of Justice Suryakant. Justice Suryakant's judgment. It sets out, my lord, some procedure. It may help your lordship, lord, in formulating this order.
Real estate.
It may help your lordship formulating this order.
That probably
Yes.
where the MPID court started selling the property.
Right.
And virtually those were going in peanuts.
So, my lord, I thought this was the closest we could get. The lordship has set out the prayers. See the first prayer, my lord, direction to so and so to liquidate the attached assets in 6 months. Then direct distribution to genuine investors, etc., etc. Then the court goes into details. Companies are mentioned. SEBI, registrar companies, everybody is here. Then, my lord, the lordship will find page 5, pages are at the bottom. Page 5, subclause G. There, your lordship will find penalties on those companies, recovery proceedings of 3,000 crores, immovable properties attached by Maharashtra Mineral Protection of Depositors Act, Mumbai. Then next page, MPID and SEBI attached, then FIRs, in different states. And then paragraph 4, page 8 may be seen. Your Lordship then culled out, what will the questions be? Location of properties, encumbrance, physical possession, disputes, market value, liens, machinery to be evolved, mandatory procedure.
Where is it?
This is by the company which has entered into terms
Now, my lord.
by this application.
That's all right, then say that.
Now, my lord, para 7. That's the para 7 at page 10, my lord, at the bottom. Keeping these exceptional peculiar circumstances in view, we deem it fit to invoke a clause 142 so as to do complete justice. We constitute a committee. Justice Bhatt, Justice Satish Chandra of Allahabad, SEBI, states, the registrar, my lord, Deputy Secretary Home, Maharashtra, who's in charge of UOW, on the next page. Then they can have, my lord, engineers, accountants, etc. They can obtain all documents, prepare a database. Then, my lord, SEBI will also be there. The committee will take steps, my lord, to properties are entrusted, encumbered, etc. All this, my lord, will be done. Something like this, my lord.
Union and the Amicus filed their.
Exactly.
Right. I just wanted to, my lord, inform the bench that this is the closest that I could get in terms of an order, my lord, of this kind of a problem.
So we will consider.
My lord. That's all I wanted.
There are several other IAs also which are not listed.
May I say something, my lord?
All IAs will.
If everybody stops, then we
May I-
will start dictating.
My lord, one additional request, my lord, at the end of it, I am the 89th property, my lord, where parties have settled, there's a mediation report pending before this court. Mr. Naidu is appearing.
I have
for
no
the
problems.
buyer. He's for
There's a
Vabe.
mediation and I have no problem.
Home buyers have.
I'm on the home buyer.
After, have you examined the 89th property?
Which property?
The property in Coimbatore.
It says the 89th property, which is
Not the 88.
That's in Coimbatore, let's put in sealed cover and.
Some of them are subject matter.
We have already deposited part of the
What I'm
amount.
suggesting is, as on today, there are 60 and odd IAs which are pending for consideration. Now, we will have to prepare a tabulated statement about each IA. And then it is possible for us to collate how many matters are how many properties are subject matter of dispute in your lordship's court. Because ultimately everything has to be resolved. All these 60 applications have to be put an end to. Otherwise it is endless.
That is the suggestion that Mr. Solicitor as well as Mr. Civil says that.
Therefore, I suggested I will.
Be done by some other court because this court can't decide all these.
Exactly.
Therefore, I suggested that once the Sahara pays the principal amount and the.
How will I pay?
How many times you will say the same thing, Mr. Navdi? From where will they get the amount? If they don't sell the property, so how will the amount come?
So they say in the sealed
Only
cover.
There is a list of properties in the sealed cover.
So they have put some properties in sealed cover which nobody knows. But some of those properties.
Before your lordship.
Now, how can we accept that, that's something somebody has offered them, why should we accept it right now? Unless we heard the other party, that 9,000 you are asking, that somebody has offered to them.
So the point today is very
That will
simple.
imply the amount that as if you are accepting that itself. We don't want to do that.
My apologies, my lord, it is not. My lord, these are properties over and above the 88 properties. These are separate properties in a sealed cover which are worth
There is
1 lakh.
nothing. We are not entitled to sell a thing, my lords. Moment we try and sell, we've tried for years and years. We've not been, my lord knows about it. Yes, it has to be sold together in a basket. Otherwise, it won't be sold. That is why you have, remember what happened in Warsaw, my lords? 5,000 crores, the deal couldn't go through.
But Sahara itself has negotiated.
Every claim is.
Each other, otherwise.
Once the decretal amount is secured, what they do with their property.
for people whom I am appearing, they are willing to deposit the balance consideration, everything is created, agreement to
bond.
sell, amount is there. So people like us, we may deposit and any
several
audit
such-
pass ballot on that aspect.
How do we know these documents are genuine document, bogus document, fraudulent document? How do we know?
Well, we have made the payment in the SEBI account and to Sahara. Well, the account transfer is there.
Leave it.
Well, that is there. We'll pay the balance, the pilots by direct.
Yes, thank you. The application number 232665 of 2025. This application has been filed by Sahara India Commercial Corporation Limited, taking various directions, including approving the transaction as contemplated under the term sheet dated 6 October 2025, executed between the applicant and the Adani Properties Private Limited. Several other directions have been got. Correct. The learned Solicitor General of India said that it will be appropriate that before considering the claims made in the application, the Union of India, through Ministry of Finance, as well as the Ministry of Cooperation, should be heard. We therefore direct the applicant to implement the Union of India through Ministry of Finance and Ministry of Cooperation as a non-applicant to the application. We further find that it will be appropriate that the Union of India, several claims have been raised before us by various interveners. It is submitted that the application also consists certain properties in respect of which the rights have been crystallized between certain parties, crystallized in favor of certain parties. The learned solicitor also but that the competing claims will have to be considered before some forum. However, it will not be possible for this court to consider each of the claims. Correct. After the learned amicus said that the Sahara India Sahara India Commercial Corporation to be first directed to deposit the balance amount of 9,000.
Sorry, not Sahara India.
Not this Sahara
Sahara India Real Estate and Sahara Housing.
Housing. These two companies, Sahara Housing and Sahara Real
India
Estate.
Real Estate and Sahara Housing. Sorry, brother.
9,481.
Amount is 9,481.
There's some dispute on that. Therefore, let's say,
approximately.
Would we consider the application? It will be appropriate that the Union of India, the SEBI, and the learned amicus examines who will tabulate the rival claims in respect of.
Sorry, tabulated.
You all can give it to amicus. No,
how will that happen?
Amicus has been tabulating it, my lord. A detailed tabulation he has already prepared.
Amicus can do it.
Some chartered accountant.
Tabulation there.
Well, my request is, it should be done by the oversight committee who claims or what claims.
Colleagues to go through this exercise. It can be waited by you.
Yes.
So there are 88 properties, but the last item says other properties where there is no description. in their IA, they have referred to 88
In
properties.
respect of 88 properties, somebody can apply the mine and find out if there are any claims with regard to that.
Correct, correct.
Can the Union of India do it?
So the Sahara must
It
disclose.
could be disputed. Instead, if the amicus does it, there may be some objections filed by some of the applicants which may not be relatable to 88. something else. So you would have the larger picture.
The Sahara must disclose whether there are any third-party claims.
Yes. No, Sahara was bound to do that, Malad, because they know.
We don't. I mean, some of these things we don't know. In fact, we have no idea. Some of these things.
No, but if you have sold them or.
No, Malas, we have not sold. Malas, your lordship must understand the employees here have been dealing with it. We are not involved in it. So we have ourselves come to light and we ourselves filed some applications. So there's a problem, Malas. Therefore, that's why the agreement says other properties, whatever, because we don't want even a single part of it. So as and when that are discovered, Malas, it will be dealt with.
Well, it's the problem with Sahara is every time they change a stand.
Yeah.
Initially, my lords permitted them, as Mr. Dattare has said, if it's 90% circuit rate, you can negotiate along with the affected parties and settle. For example, Coimbatore property millets, they negotiated along with the home buyers, and we have had a settlement, and there's been placed before lordships, advance paid into SEBI's kitty. Now they say that no, let it be in whole hog.
No, I have not changed. I have said yes, in fact, on the contrary.
Yes, you have agreed and you have signed along with those who have got the stakeholders.
I've said yes.
Even before us also.
I said yes. I don't know why you haven't heard me.
So the normal course in execution of a decree.
If you nominate one of your juniors to collect that information.
Yes. So we can collect it only on the basis of pending IA.
Mr. Nagpal, because all these applicants, interveners or applicants who have applied, they must have given a copy to your office.
Yes, some IAs,
Based upon
60
that-
IAs we have got.
Based upon that, you please depute one of your assisting counsel who can be an assistant.
Yes, we'll do. That is what I suggested initially. That third-party claim.
Counsel will prepare. One is the list of the undisputed title, second will be disputed, and third can be doubtful. Doubtful
Also, my lord, we
that
could
from the face of the document appears to be doubtful.
But as I indicated to your lordship, that the last item in their list which Sahara has given, it says other properties where there is no description.
We'll come to that later.
In the process, you can ask the Sahara to provide you the information wherever they provide.
have it, we'll provide.
Very well.
Put a remark column that this information not available.
Very well.
And that chart, a collated information can be brought in.
So long as it becomes clear that whatever Adani is buying comes with whatever claims that there are, and those claims can be adjudicated by some forum, there should be no problem. So for instance, in my Lord clients, they own the land. They had an agreement with Sahara to develop it. So, and Sahara was to get 90%. Now they have a certain claim. They're saying that the agreement is gone, etc. Some forum will adjudicate on that. Otherwise, we have no problem. Instead of Sahara, Adani will come. That is not an issue.
Court decree in his favor. Why should he then again go for a claim?
What I'm
It
suggesting
will be endless.
let all these
Therefore, all
applicants,
will have to sort it by law.
let all these applicants lodge their claims in a tabulated form with me, and I will prepare a consolidated statement.
Correct.
Otherwise, it is haywire.
You can be assisted by a team.
I have got
You got, then it's fine.
more
You can
competent
add to
than
the
me.
team. You can add to the team.
My lord, my issue is completely different, my lord.
Kochi property, where the investor, not buyer, we have invested since 2014. 10 years have passed. Large buyers were paying to the bank installment. And we are waiting for the flats. 50 crores.
IA 9 and 10 for salaries, my lord, the employees' salary.
Now you have said that at least 10 times. But we find that before we consider the application, it will be appropriate that the parties who claim to have any rights in respect of any of the properties listed in the application shall lodge their claim before the learned abacus person. We request the abacus through abacus to nominate an assistant counsel who shall collect the said information in a chart showing the properties where there is no dispute, the properties where the rights are crystallized, and the properties which are under the shadow of doubt.
Also, Lord may also include settled properties. There's only one, settled properties.
That is crystallized.
There is a mediation report.
Malad, let them seek a response from us before they finalize, because we also must know.
My other suggestion is that today we have number of applicants before the court. Now, if there is some other third party, that Sahara should disclose.
No, if we know, we certainly disclose. I mean, I know. Why are you saying? But we should be allowed to respond, Malad, to respond to that.
Sahara, India Swansu would also be entitled to give its input.
Yes, exactly.
The learned abacus. In addition, we request the Union of India, the learned abacus, as well as the SEBI, to respond to the prayers made in the IA paragraph. Insofar as the IS concerning claim of the workers, claim of the employees is concerned, but we direct the Sahara to examine their claim and respond to the same on the next date.
Yeah.
Please.
Your Lordship, I have filed an IA which has not been listed. Your Lordship, this IA was.
You have already said that we are not said A employee or B employee. We have said that I concerning the claims of the employee.
Your Lordship,
My lords, may I be permitted to withdraw an IA? My lords, may I be permitted to withdraw an IA for intervention, my lords? It will reduce the cost.
Whoever wants to withdraw, they can give their names. You also want to withdraw.
Your Lordship, my IA is not listed. It was actually, the civil decree has been passed in my favor, but the execution is pending due to the order of this honorable court, Your Lordship.
Okay, we will consider it. You also give lodge your claim with the learned amicus.
I have already supplied the copy, Your Lordship. My IA may be listed on the next date, Your Lordship.
So far as my offer is concerned, my lord, the amicus will consider and Sahara will.
That we will consider. Whether the properties are to be permitted to be sold in a piecemeal or in one block.
That's right.
I am also asking for 700 acres of land, my lord.
Maybe we will decide whether we have to follow that Golden Forest order or some other order.
Exactly.
I am willing to match the offer.
Lordships.
If you are willing to match the offer, then match the offer for the entire property.
Not the 88 properties. But
Lordships, there are certain IAs regarding the 88 properties that are not yet listed. Lordships may clarify that those IAs be also be listed, my lords.
20, Lordship. Number 20, Lordship, purchase of property owned by subsidiary company of Sahara Group, Lordship.
Whoever has any claim in respect of any of this property, you may give a.
There's an incumbent in that property, Lordship.
So there is no comment, then it will come in.
Lordships may clarify irrespective of whether their IA is listed today or not.
Lords, in the
number 20.
Lords, in the IAs for the employees, may I, my lords, only.
Narrate solicitor, when do you want it?
Lord, maybe 4 weeks, my lord, because the learned amicus also will need that much time, my lords.
And the application will disclose. I just want that you my conflict under section 9, you can proceed further. Lordships have already granted that indulgence to us.
Same clarification, my lords, I am seeking in seal number 23 and 24, my lords. 4 weeks. Listed IA, my lords.
Employee issue, my lord, maybe.
This application on the next day, whether they can be granted liberty.
The commercial terms are not disclosed.
No. I'm talking about the IAs of the others.
Yes, my lords, serial number 23 and 24.
My lord, employee issue order has been passed earlier, my lord, similar order has to be passed, my lord.
It is dated 3rd September and.
It has to be cleared from Sahara SEBI account, my lord.
We'll have to file a reply to all that.
Yeah. That today.
And it's very small amount, my
lordships.
Where Mr. Napoli for collating this information?
For properties or for these IAs?
No.
Yes, both.
Only one, their IA, we will have to respond as to they should be permitted to enter into that transaction.
After Diwali vacation. After Diwali vacation, about 2 weeks thereafter.
4 weeks from today.
4 weeks from today.
All the claims.
Lordships may clarify that even those purchasers whose IAs have not been listed be permitted to approach the learned amicus. Lordships. Lordships, Lordships may clarify that even those purchasers whose IAs have not yet been listed.
The parties who have any claims.
Small clarification, Lord, that even companies can be sold by Sara, Lordship.
If the properties are included in 88, you are concerned. If the properties are not in that 88, then you are not concerned.
Lords, for the employees, I have just.
Only, my lord, implies IA may be disposed, my lord. It's very small issue, my lord.
Properties, my lords.
All of you can give your details to the learned amicus. As one of the CJ has already dictated, you will identify the properties which
Your
are
Lordships, earlier on,
under title,
September covers that interest as well. There's a clarification already.
serious dispute regarding title or where there is some cloud. Then
Recorded, Your Lordship. That means recorded in the order because
Implies IA.
company, Lordship. It's not the main two companies, Lordship.
The properties of all companies are directly be sold.
My lord, implies payment has to be cleared from Sara SEBI account, my lord.
Does 11th November suit you?
11th.
Which date?
11th November.
Very good.
That's fine.
My lords,
11th.
some of the crystallized properties are in sealed cover. They have to be given access to the learned amicus to know, so that we can represent.
So if you have any claim, you lodge the claim with him. Then
Based on your lordship's direction, negotiated, settled, advance paid, and that MOU was placed before your lordships in a sealed cover.
That is not, that is the Coimbatore property, my lord. That is not part of this.
We are agreeable to that. We are agreeable to that.
So you'll have to say that.
I said that twice over.
Once more.
I mean, you can't keep on repeating the same thing. He says, no, I didn't say it. I said it.
As regards to the Coimbatore property, the matter is not settled. A large number of home buyers.
22 out of 511.
EP is filed, properties are attached. So behind the back, the settlement is.
22 out of 511.
Orders. You have not filed.
My lord,
All IAs be listed, not all IAs in this matter be listed.
my lord, SEBI doesn't have objection. I just spoke to Mr. Venugopal. He doesn't have any objection.
My lord,
My lord, if
there is an
implies
order of
paid
your
from
lordship.
Sara SEBI account, my
No, my lord, that order of 4th September 2024 says they have to file affidavits. That has not been complied with.
We will file it. We will
Yes,
file
they have
it.
not, no, we have not got any affidavits. They have to file the affidavit showing that the claim belongs to a group company whose assets have been sold. Unless that affidavit is that order is complied with, there's no question, my lord. Because, and secondly, my lord, Saharas have to disclose whether they are employees or not. Now, many people are claiming.
That is what you have said, that
Yes, my lord.
Sara should respond to the.
Exactly, my lord.
That's right.
Lordship, please.
Lords, I want to give their response to the amicus who may verify with regard to the employees also, Lords, because.
That is what we have already
said
said.
already. Why? How many times will you say the
Can
same
I-
thing?
Chorus, you don't listen to what we dictate.
I don't know what's
So
wrong.
instead of 11th, can I have it on 17th?
Not all IAs be listed.
On 11th, there is some difficulty. Can I have it on 17th?
Yes.
All IAs be listed. IAs be listed.
Would you?
All. You lodge the claims with them. It's not necessary that the IA should be listed. That's right. With the IA being listed, we can also consider whether there are any claims on the parties.
Yes.
Would your lordship be reassembling, my lord? Would your lordship be reassembling, my lord, for the main nature? Today, my lord?
That part of matter is.
No, I'm just asking, my lord. Would
Yes,
your
yes,
lordship
yes,
be-
yes.
Yes, the other combination will sit for a parted matter, Mr. Sibal and
Oh, I see.
Mr. Raju.
Parthad, no other matter will be taken.
Except one, I think, for directions that is.
Please.
32, I think.
Please,
Lordship,
grateful.
Lords, may I only mention, my lords, item 22 listed in the morning, my lords. Here the husband had flown the Indian jurisdiction, my lords, taken the child, punished for contempt. Only one IA for 142 divorce was pending. He's got a divorce in Kenya. This is that Ferry Kansagra, madam, lords. If that IA could be taken up, notice was issued in 23. The man has not, he's not appeared since 21, my lords. If that IA could be kept, my lords, immediately after Diwali. Obliged.
Item 6, Your Lordship, testing the virus of the UP Gangster Act, Your Lordship. Matter has been listed twice in the past. Today it was also listed, Your Lordship. Could not be taken up because of the board's discharge. May indicated date, Your Lordship.
Item 18 is listed only for an application for early hearing. Mentioning has already been permitted twice. After mentioning, only the early hearing application has been listed, which I had filed as far back as in March. I know this is a matter pertaining to the encounter killings in the state of certification. I'm only seeking that a fixed date may be given because it's not showing on the regular list since January.
My lords, item 34, my lords, Your Lordships will allow the mentioning for the matter to be lifted today. Parties had settled it, my lords, way back in July before the mediation center. It's coming up for the joint application for dissolution. Friday, my lord. So grateful, my lord.
Your Lordship, at 26 बाईस जुलाई को हमारा हुआ था, नोटिस हुआ था, 22 जुलाई को कई बार बोर्ड पे आ चुका, अभी भी मेंशनिंग करते हैं, आज लगाने का कल के लिए लगा। This is content with land acquisition.
There is an MA in content.
Yes, what is the matter about?
Asking for compensation. He has got one the reference for compensation. He is filed. My lord, argument will be done by my counsel. Counsel has been appointed by this.
दिवाली के बाद का रेट
कल मैं मिला
दिवाली के बाद का रेट
Your Lordship, I filed an intervention application, item number 6, my lord, related with the Gangster Act, my lord, and the police is threatening and raiding my houses, my lord.
Yes, yes.
My lord, I'm slightly digressing from my submissions. Facts I will take a little because there's another important submission that I'm making, my lord, is this. They want reading down of a provision of a central stat. They want reading down of a central provision of a central statute to section 2S. That is the alternative prayer, my lord. My lord, first prayer, which was the amended prayer. Now that prayer cannot be granted unless the union is made a party, my lords. Kindly have a look at one judgment of this honorable court. That is 2023 8 SCC 745. Union is not a party in these matters. It's a provision. There are two. Para 8 of this judgment first, page number 37.
Read down, frame the
Page 37, para 8. Rerun A. My lord, the Chief Justice. But just the sentence starts one line above the dotted line. Another question which is required to be considered. My lord, so got it. Last line of page.
Yes, another issue which is required.
Yes. Well, yes, in the short issue before the bench is whether the judgments in Ranif and Arubian have been correctly decided whether active membership is required to be proven over and above the membership of banned organizations under UAPA. Another issue which is required to be considered by this bench is whether American decisions concerning freedom of speech referred to in Ranif to which this court agreed could have been relied upon while considering the right of freedom of speech available under the Constitution of India, more particularly Article 19(1)(c), 19(4) of the Constitution of India. Now, this is important. Another question which is required to be considered is whether the court was justified in reading down a provision, section so-and-so of the UAP Act, without impleading Union of India as a party, and more particularly when the constitutional validity of 12 provision was not called into question. Then, my lords, may kindly have a look at para 25.4. 25.4 at page number 49.
Yes.
On the submission made on behalf of the Union of India that without hearing the Union of India, this court ought not to have and or could not have read down section so-and-so of the UAP Act or section so-and-so of the TADA, the Sanjay Parikh learned senior counsel has relied upon decision of this court in Sanjeev Coke versus Bharat Coking Coal Limited. It is submitted that in the said decision it is observed and held by this court that no one may speak for Parliament and Parliament is never before the court. It is further observed that after Parliament has said what it intended to say, only the court may say what Parliament meant to say, none else. It is further observed that once a statute leaves Parliament House, the court is the only authentic voice which may echo Parliament, and the court will do the same in reference to the language of the statute. It is submitted that while reading down section 10(a)(1) of the UAPA Act and section 3(5), the court has interpreted the statutory provisions in light of 14, 19, 21 of the Constitution. It submitted judgments in reference correctly hold that mere membership of the banned organization will not make a person criminal unless. Then kindly have a look at para 59. Now, so far as section 10(a)(1) of the UAPA 1967 by this court in Arup Vihan is concerned, at the outset it is required to be noted that such reading down of the provision of a statute could not have been made without hearing the Union of India and or without giving any opportunity to the Union of India. Today, the Union of India is not before my lords. 60 also. Para 60, my lords. When any provision of parliamentary legislation is read down in the absence of the Union of India, it is likely to cause enormous harm to the interests of the state. If the opportunity would have been given to the Union of India to put forward its case on the provisions of section 10(a)(1) of the UAPA 1960, the Union of India would have made submissions in favor of so-and-so, including the object and purpose of enactment and such provisions, even the object and purpose of UAPA. Submission made by Sri Parikh, learned senior counsel, relying upon the decision of this court in Sanjeev Court that it is ultimately for the court to interpret and read down the provisions to save any provision from declaring an unconstitutional is concerned. It is true, it is ultimately for the court to interpret the law and or particular statute. However, the question is not the power of the court. The question is whether it can be done without hearing the Union of India. Therefore, Union of India is not a party. They may implate or my lords may direct Union of India. Then my lords may kindly have a look at the next page. Second paragraph, just above para 63. At the cost of reputation, it is observed that reading down a particular statute, even to save it from unconstitutionality, is not permissible unless and until the constitutional validity of such provision is under challenge and opportunity is given to the Union of India to defend a particular parliamentary statute.
Come this, cannot be Indian as a party.
Even if this prayer is not allowed, Mullahs, all the other matters are matters of investigation. I'm sorry?
They will give up this prayer. See, federalism prayer.
Unless reading down can be a prayer.
Without.
It can't be, Mullahs. So many times under section 45, Mullahs, of the PMLA itself, it was read down. It is not that the Union of India had to be mere party. Income Tax Act, Mullahs, you read down several provisions. Union of India has not made
the party. I'm sorry.
You challenge the constitutionality in a given circumstance, the court may feel that to uphold the constitutionality, you read down the provision and ensure that it is there.
That's correct.
But then can you make a prayer for reading down as such? Is that?
Correct, Mullah. You can otherwise read it down, Mullah, even if you don't make a prayer.
That is only if there is a challenge on the constitution.
Mullah,
That's going to be my second submission. Electronic corporations.
Let's assume, Mullah, that you Lordship don't grant me that prayer. My basic objection is, Mullah, that they are investigating the matter which is a predicate offense. Corruption will be investigated by the state, not by ED. They say that there are individuals who are corrupt, Mullah. Otherwise, if we give consent, CBI will investigate corruption. Otherwise, the state will investigate. Who is the ED to investigate corruption? Who is the ED to investigate corruption, Mullah?
I am not investigating corruption.
Right,
I am not investigating corruption. I'm only investigating money laundering.
That's
I am not
case.
investigating corruption.
There's their case, Mullah, in the counter. These people are corrupt. Just see their paragraph.
Wild allegation made. I am not investigating corruption. I am making a statement with all seriousness.
No, 1 second. But now that I'll answer that, kindly come to page 2 of their prayer. Page 2, para 5. Regional managers, taskmaker are indulging in collection of bribes for transfer of posting. What has that got to do with ED, Mullah?
Description of the predicate offense.
Officers in level of district managers and senior managers are indulging in high-level corruption. What has that got to do with ED, Mullah? Just see that FIR has been registered on the issue of representatives of breweries approaching taskmaker to take off high take. What has that got to do with ED, Mullah?
It's only
everything that they are saying in their counter relates, Mullah, and they have investigated none of them. They have only investigated the corporate office. Mullah, they have not gone to any regional manager. They have not gone to any district authority. They have not gone to the breweries. They have not gone for transfer. Nothing. They are only rated the corporate office. And FIRs were being registered from 2017. May I just tell your lordships? This is very telling. Since they have been investigating, we have been lodging FIRs in 2017. How have they rated in 2025? Many of these FIRs have been closed prior to 2021, 2022.
Correct.
They are.
Are you pressing for this prayer?
No, we need not.
No, now.
No, I will not press for it.
You say that we will record the.
Yes, your lordship may record it. Let him justify, on what basis he is proceeding.
We are against.
Yes, he is not pressing for that.
Very well, I'm obliged.
Though I have some problem with the proposition.
He gave up the prayer in federalism in the High Court. Now he's given up even the. Very well, Maharaj. Now kindly have a look at the other prayers.
Actually, in the course of prayer
163, my lords. My lord, ordinarily the courts do not interfere in investigation. Your lordships have held that investigation is the domain of the investigating officer. How and where and when to investigate is the domain of the investigating officer. It is settled by a series of judgments. Sole prerogative of the investigating agency may have 12 judgments on this point, my lord. So whether I have to search place A, B, I don't have to take anybody's advice. Even the courts should not interfere in such matters. But I have a compilation of judgments, my lord. Can we give the hand over the compilation of judgments? Kindly have a look at JSS Saldana, my lord, which starts at page 238. Relevant paras are 19, 25, and 27. Page 261, my lords may have a look at para 25, my lords. There is, my lords have got page 261, para 25. There's a clear-cut and well-demarcated sphere of activity. I'm sorry. 261, running page 261.
Yes.
There are 25. There is a clear-cut and well-demarcated sphere of activity in the field of crime detection and crime punishment. Investigation of offence is the field exclusively reserved for the executive through the police department, the superintendents over which vests in the state government. The executive, which is charged with the duty to keep vigilance over law and order situation, is obliged to prevent crime. And if an offence is alleged to have been committed, it is the bounden duty to investigate into the offence and bring the offender to book. Once it investigates and finds the offence having been committed, it is the duty to collect evidence for the purpose of proving the offence. Once this is completed and the investigation officer submits a report to the court requesting the court to take cognizance of the offence under section 190 of the code, its duty comes to an end. On a cognizance of the offence being taken by the court, the police function of investigation comes to an end, subject to the provisions contained in 173(8). That is further investigation. There commences the adjudicatory function of the judiciary to determine whether an offence has been committed, and if so, whether by the person or persons charged with the crime by the police on its report to the court, and to award adequate according to law for the offence proved to the satisfaction. Thus, there is a well-defined and well-demarcated function in the field of crime detection and its subsequent adjudication between the police and the magistrate. This has been recognized way back in King Emperor versus Khwaja Nazir Ahmad, where the Privy Council observed as under in India, as has been shown, there is a statutory right on the part of the police to investigate the circumstances of an alleged of cognizant crime without requiring any authority from judicial authorities, and it would, as the Lordship think, be an unfortunate result if it should be held possible to interfere with those statutory rights by an exercise of inherent jurisdiction of the court. The functions of the judicial and police are complementary, not overlapping. Therefore, ultimately, a series of judgments have taken the view that investigation is the exclusive domain of the police authorities. If that is so, unless there is totally arbitrary action, totally unconstitutional action, the court should not interfere and should not direct that you search this place, search that place, do something in the investigation. Now, as far as the other judgments, I need not refer, but they're going the same line, so I need not refer to the other judgments. Now look at the other prayers. Now kindly come back to page 163. If the constitutional aspect and reading down is left out, what are the prayers? It essentially tantamount to interference with investigation. And also consequential prayers. There are some in the other petition. Now kindly have a look at page 163. Of the SLP. So if you ignore the first prayer,
taken by you?
By us? We have registered an ES by the state or by us?
By you.
We have registered an ECIR and we have searched this. We have not arrested anybody, nothing. And thereafter there's a stay.
No, but after ECIR, have you taken any steps on the basis of that ECIR?
We have recorded some steps. We have searched these premises and recorded statement. That's all. Nothing else has been done. We have searched distillers. We have searched the TASMAC office.
Have you proceeded against any of the accused?
No, we have not arrested any of the accused. Nobody is arrested. Nobody has been, nothing has been done. Before we unearth and get evidence, this petition has been filed so that the evidence disappears and we don't do anything and huge corruption is swept under the carpet. ECIR, where's the ECIR? ECIR. I've asked my officer to remove it. It's not there, but I've asked my officer to remove it. You got a copy? You got another copy? Yes, we got it. It's an internal document. ECR is an internal. Vijay Madanlal has said not akin to an FIR, not statutorily required to be registered.
This is correct, this is not correct. The import is selling. It's sovereignty of the nation. I just said There's also reason to believe this question by the High Court. High Court has said this is not completely. And also, you can say that yes, the review provinces can be. I think this is very difficult to speak with it. Was to be placed to meeting. No, I know, but I mean, I don't know what that means. It's not even. The expired in 2016. 26. They have waited and election is after 4 months. Yeah. That's it now. I mean, it's all fixed. Why this? We have not gone again. We have just got recorded a statement and got.
No, against Mr. Senthil Balaji.
That's a different case.
Cash for jobs.
Cash for jobs scam.
In the transport department.
In the transport department, that's a different case.
This court has granted him bail.
This court has granted him bail. He's not arrested in this case. But we have got material which shows, my lord. Therefore, my lords may kindly have a look.
So because most of the allegations are against him in this, yes, he are.
Material that has been got is the allegations, material which has been obtained is why he is confronted, he is denied. It's not material we have gathered. And we have found that.
This is akin to an FIR, is it not?
No, it's not akin. Vijay Madan Lal says it's not akin to an FIR. FIR is statutorily required to be registered. It's only for internal purpose.
This, you will proceed with the investigation and register the FIR.
No, we register a prosecution complaint. We lodge a prosecution complaint. We are not, the moment we register a charge sheet, we become police officer. We are not police officers, therefore we file a prosecution complaint.
ED doesn't supply ECIR copies to the accused person.
There are authorities that
That
issue is pending.
Safeguard of an FIR. Under a lordship judgment, an FIR has.
Vijay Madan Lal is clear.
The net within 24 hours, so people can read it and go and apply for bail. ECI has registered in their office. Nobody knows. Suddenly you can go and pick up somebody and say, well, we have an ECI, that man has no idea. This is the procedure.
They don't tell him they can
This very
record a
challenge
section
was
50
there in Vijay
statement,
Madan Lal. Now
and
Vijay
that now
said,
subject
now
to
in
review
review
before
they have
3
raised
judges.
up this issue
It's very
again.
matter. Therefore,
This
really,
very
this is nothing.
challenge. ECR is not an issue. The copy of the ECR is not an issue in this matter. But they have not asked for it. They have not asked for it, but Vijay Madan Lal categorically says there is no statutory requirement to register.
You know it's under
we
review.
may start investigating without an ECIR also. There is no requirement in law that we should register an ECIR. But administratively, we are doing it.
High Court directed them to supply, they didn't give, but that's Vijay Madan Lal Chaudhary. That's why you didn't give.
Vijay Madan Lal Chaudhary says.
And
but
that's under review now.
My lord, now I have advised the ED that you just record an ECR saying that these are the FIRs, give them a copy.
Good. You should do that. At least we know what's against us.
You can give them a copy.
Even
But why should this document not be supplied to us? It's about Senthil Balaji. Why should it not be supplied?
At least in that case.
Yes.
Why the
Volume 3, 4, 5, 6, 4, 5, 7 is here. ECR may not be shared.
Other side, but can the court peruse it?
Of course, court can peruse it.
Something like a case diary.
It's not the case diary is the file. Because the court can always peruse. There is no impediment. No.
Under CRPC,
172C.
the courts can refer to
Always.
a case diary, but an
Nothing.
accused is not entitled to have a look at.
Yes. Nothing, my lord, we are not shy of giving anything to the court. But our investigation is at a threshold. It will jeopardize an investigation if material is given to them. They will know, they will ask for retraction of statements. So many things will follow. Not at this stage. And the issue is wide open before the review bench of Vijay Madan Lal, where they've said ECR copy has to be, though Vijay Madan Lal says, no, it's not a statutory document. There is no requirement in law to register an ECIR. I can start investigating without an ECIR.
Why don't you do it?
Vijay Madan Lal, may I hand over the copy of Vijay Madan Lal, which category deals with this point, my lord?
No, that's conceded. That Vijay Madan Lal, that's under review. You know that. There's an order of the court. Let's talk about the facts as to what you're doing. With Senthil Balaji, tell us that's your objective.
And that's not my objective.
If this is what the ECR says, Senthil Balaji, that's your objective.
Our
You are protected. No, just here, sir. You are protected. Now that other judgment is under review.
Yes.
See, if at all we do something here, we will be bound by the 3-judge bench. It's a 3-judge bench.
Yes, 3-judge.
Still, until it is reviewed, it cannot be possible for us to say anything against that.
Whereas I'm not on ECIR. At the moment, I'm not.
No. We know you are not on the ECIR, but then on a consideration, we'll have to look at it in a comprehensive manner.
But he is saying that your lordship may look at it.
Other judgment stares at us, which is also under review. Why not we adjourn it and hear it after some time? Let the review first be decided on that.
Well,
Probably this could also go to the.
The problem is the following, Malas. I just want to give me 2 minutes. Problem is the following. Their submission is that every time there is an FIR lodged anywhere in the country, ECIR can be lodged by the directorate. That's the law. Because that's what Vijay Madan Lal Chaudhary says. Because once there's a predicate offense.
So that is why we are saying that when that is under review, why should?
No, that's not under review, Malas. That's not under. That's the issue.
So Vijay Madan Lal Chaudhary.
On the ECIR is under review, not what I'm telling your lordships. Malas, their proposition.
There, my learned things are different.
Will your lordships give me 2 minutes? Malas, just kindly come to section 3 for a minute of the PMLA. This is the real problem is this. And we've been waiting for years.
We just now read section 3. We read section 3.
PMLA.
That's how we started asking you this question.
Of
We read
PMLA.
Section 3.
Of PMLA.
Yes, PMLA. That
Yes, now Malas, that and origin converted to or.
That is approved by Vijay Madan Lal.
Just have a look at that for a minute. Malas. This is the real problem in the case. which is why they're run, I don't
Vijay
mind if I
Madalal
say.
dealt with this issue
Will you- will you-
extensively.
will you allow
And
me-
or,
will you
re-argue Vijay
will you
Madalal.
allow me? I'm just.
Every time he argues Vijay Madalal, I'm sorry.
Every time you argue the same thing, no? No,
Because
but
that's the-
whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with proceeds of crime, including its concealment, possession, acquisition or use and projecting or claiming it as untainted property shall be guilty of the offense of money laundering. So, Maharaj, whoever is doing this and projecting it as untainted property.
You can't argue contrary.
I
to
am
the
not
reason.
arguing, I'm just explaining something.
To the submissions there.
Well, it's just, will you allow?
Very well. And that's
This-
not even an issue here. I'm sorry.
Now, Maharaj, what happens, then an explanation comes. And this explanation is in Finance Act 2019. What does that explanation say? For the removal of doubts, it is hereby clarified. A person shall be guilty of the offense of money laundering if such a person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with proceeds of crime, namely concealment, possession, acquisition, use, projecting it as untainted property. So the explanation changes and to or, upheld by Madan Lal Chaudhary. So, Maharaj, there is no difference between proceeds of crime and projecting it as untainted property. Result is that every time there's an FIR lodged anywhere in the country, ED goes in. ED goes in and says there's an FIR, predicate offense is there. I don't have to go into and projecting it.
Because of Madanlal Chaudhary.
That's the explanation. Yes, you're right. You're right. Now, Maharaj, the question is, it's a corruption. Corruption involves individuals. How do they raid a corporate office for corruption? My objection is.
Now, see, you are not holding cudgels for all the FIRs which could be registered. You are concerned with your case.
That's right.
Let it come after Vijay Madanlal's review is all we are saying. Why? You are protected fully.
Yeah, but therefore, I want this all proceedings quay the corporation because it's a government corporation. It has nothing to do with individuals.
You are protected. You are protected completely.
Yeah, then also may grant rule, Maharaj, grant rule and let it come up. Grant rule and let it come up.
Leave granted. For hearing parties, the receive order, self-stand confirm.
Let it come up after the review.
Yeah, appeal to come up after the review. It's Vijay Madanlal Chaudhary is decided.
Yes. And then there are those privacy matters, Maharaj, those all may come up together, Maharaj.
Which matter?
Those
That's a
privacy
different
matters
matter.
of mobile phones, that also is
How can
involved here.
a corporation talk of
Future
privacy,
gaming,
but no individual is before my lords?
Read petition 515 or 20.
Swami says corporation not entitled to privacy law.
This be tagged
Fundamental
with
rights
petition
not there.
515 of 2024 also, Maharaj, because the same issue will be involved there.
My lord,
That involves
observe that
mobile
he's given
phones.
up the prayer, my lord, he has given up that reading down prayer, my lords may observe, my lords.
No, that's all right. That I
That
don't
may be
mind.
observed
I give
because
up.
that is what is said.
But once it is rule is being given, Maharaj,
No,
we can argue that.
he has given up that prayer.
Maharaj, my
On
request
fairness,
is
my learned friend should accept this.
tag it with grid petition 515 because it also involves seizing of mobile phones.
No, it need not be tagged.
302, Maharaj, in our SLP, 302.
At least his statement may be required. He made a solemn statement before this court.
Mobile phone seized in this case is the instrument.
After Vijay, we don't know when it will be reviewed because for last 3 years, I've been hearing that it is being reviewed, it is being reviewed.
Maharaj, we've been trying very hard, Maharaj, but somehow. So,
Last
Maharaj,
time the learned friend-
515, tag it with 515. Kar diya, deeply obliged.
In our case, there's no seizure.
And once, Maharaj, the elections take place, then there'll be no interest, Maharaj, because this all happened in
I'm sorry,
2015.
no.
25, Maharaj, 2025. 26 is the election in 26 early, Maharaj.
No, this is not this is incorrect.
Election is 26 early, Maharaj. So this all happened in 2025.
What Mr. Sibal
Let's take the better.
Why is the learned friend politicizing the issue, my lords?
This all is.
For one.
I don't want to say anything, but I have said it here on the last day.
What my lord said in the morning is already reported. May I show that? What my lord.
I have not said anything.
No, that is all reported.
The fact that he won't say.
Very unfortunate.
That my lords will not say anything is also reported.
Which is good. Because in that statement, there is a lot already said.
So Dharmadhikari must be aware about many things.
Lord, I am not.
He's innocent.
My humble request, that statement of his that is not present.
Let it clear. It can't be granted, it can't be granted. Now, the outcome of this proceedings will depend on whether.
Made a statement. I'm only asking what he has said. I'm not asking.
I don't know what's the point of all this. You will succeed anyway. Well, he'll succeed. He'll raise the same issue. He'll succeed, Malaj. I've got a lot to say on that. Therefore, don't make any statement. We can amend the prayer. We can do many things. Yes. Why should
We can implement.
we have attacked the statute? We can amend it. We plead the union.
India was not said it in the beginning. I want to amend.
Aren't
He
you
took
amend?
a chance.
What is the problem?
I'm sorry.
We will implement Union of India as a party.
We can implead Union of India. What's your problem?
Union of India as a
We
party.
challenge the statute.
We will grant them leave to impede in another.
Yes. My lord, we grant this.
Deeply obliged. It's tagged with 515.
Yes, you have passed that out.
Yes, deeply.
The Lordship will not allow him mentioning in the morning, Maharashtra State Electricity and
Day after tomorrow. After we mentioned, my lord, we have received an email at 11:30 this morning after the mentioning, granting us time till 10 a.m. tomorrow. If in the failure of producing an order or injunction or anything, they would impose regulations tomorrow by 5 p.m. We have received that email.
They will what?
Impose the regulations under the late surcharge payment regime by tomorrow 5 p.m. my lord.
Kal serial number 1 पे बैठा है.
Lordships may have it tomorrow.
Tomorrow I have more.
Grateful, grateful.
But Mr. You have breached the rule.
I was not mentioning.
Yes.
This was very extraordinary.
No, but then we are no extraordinary.
Anyway, Your Lordship may ignore mine. I was here, so he caught me. I have not mentioned Lord after that day.
Yes.
She made the rule, I have not mentioned. This was very extraordinary for the Lord.
Grateful.
Please, my lord, on 7th of October, your
Please
lordship.
see one thing. Provident fund.
Yes, my lord.
Provident fund is not, the priority does not relate to provident fund. Let's see 26E. 26E of the SARFAESI Act.
Just
It says of notwithstanding anything contained in any other law for the time being in force after the registration of security interest, the debts due to any secured creditor shall be paid in priority over all other debts and all revenues, taxes, cesses and other rates payable to the central government or state government or local authority. So it is only the taxes, cesses and duties and dues to the central government, state government or local authority. The PF Act has a first charge. So PF definitely has to be.
The provision itself creates the
Already paid.
statutory charge. And one more thing, Lord, this dues are.
And even when you see that the judgment you pointed out in Union Bank or
MSC Bank versus the.
yes,
Yeah.
even in that,
Provident
case,
Fund
if you look at it, the Central Excise Act at that point of time did not have this first preference.
Yes, my lord, but.
That is why they said that look at section 35 of the SARFAESI Act.
Yes,
Section
notwithstanding.
35 is not to get over priority of charges. No. Section 26E gives priority of charges only as against government dues. So then what happens is PF, you will have to give it to them. PF. Then again, workmen, unfortunately, we don't have a first charge for workmen.
My lord.
Workmen's dues.
There is earlier High Court order which has.
No, forget the work. See, if it was under the IBC, the workmen have a priority of charge. And even in the company's law earlier, winding up, they had a charge. But here there is a liquidator appointed under the Cooperative Societies Act, probably. That if that doesn't provide for a what do you call preference to, does it provide? Does it? The Maharashtra Cooperative Societies Act, does it provide a preference for workmen and for liquidation?
No, only thing is, there are some judgments of your lordships where they say, the workers' dues and the secure credit carry pass that's the
No,
but
cannot.
529
By this provision that is taken over.
Only here, the one more thing, the Securitization Act came into force on 2002. The workers' dues are ranging from for the period commencing 1989.
Oh, but then, first of all, there is no first charge. And here is a case when 2002 it came. If the PF Act, if it did not have a first charge, probably then the priority would have to be given to them. Now there is first charge.
There is one High Court order, which will be directing the worker to go to the liquidator. And liquidator is directed to make the payment that has attained finality. The order passed by the industrial tribunal was challenged before the High Court. And that High Court's direction, that is 2016 order.
I will explain.
You lost before the industrial court.
That is what.
You lost before the industrial court.
Yes. Delay was dismissed. See, your challenge.
Yes,
No, your challenge, what happened was.
May I point out?
Please. The single judge only said that, considering the fact that the liquidator was appointed, let the liquidator decide.
Industrial court dismissed our complaints on the ground that there is a delay application.
3 grounds.
Thereafter, when writ petitions were filed before the High Court, that order is of
That is what I told you.
Yes.
What did the order say? The liquidator will decide.
Yes, there is one option, either go before the tribunal or to the liquidator.
No.
You took the option of liquidator.
And this was the direction. There is an order that directing the liquidator to make the payment.
The liquidator may probably compute the dues, but that is not, liquidator does not have the power to keep it with him.
And that is subject to Supreme Court order 1. Secondly, my lord, 2001, my lord, the liquidator was appointed in view of section 109. Only 6 years tenure for completion of proceeding.
Of the Cooperative Societies Act.
Cooperative Societies Act, section 109. Attest reach first 6 years, attest reach 6 years, thereafter 1 year separately up to 10 years, and after 10 years, even take his case from 201 or 202, 10 years over by 2012, then special permission from government required for a period of 5 years. That is also not there, and after 15 years termination, 15 years completion, deemed termination of winding up proceeding.
Why did you not point out that full bench decision of the Bombay High Court, which dealt with this?
Which one, my lord?
You're both from Bombay. Full bench decision where the Chief Justice, Justice Deepankar Datta, had considered this 2016 elaborate judgment.
I am sorry.
They did not cite it because it is a judgment of the High Court.
One more thing. Employees.
But one issue I have a doubt whether the substantive proceedings are over.
And my lord, that page?
Page 380 is the one
That
where the
page.
PS.
My lord, even PF dues are paid is a different, on merit I am saying at page 380, PF dues are paid, that is one. Secondly, so far as the 2001, 2009, 1 SCC page 123, my lord, that time 26E was not available, that is the point.
But PF dues you have to pay.
Yes, my lord.
We have already paid.
May I make a subtraction? So far as the PF dues, my lord. My lord, no fault of workers, my lord.
We are going to allow it.
No, one more. My lord, PF, my lord, is deducted from the salary of the employee, my lord. Now, my lord, this from 1989, my lord. My lord, I'm praying that, my lord, it may be paid, my lord, with interest, my lord.
That definitely the provision provides for that.
Grateful to you.
I'm